Under recent changes to federal legislation, employers now have a positive duty to eliminate discrimination and harassment in the workplace. In Queensland, a similar duty is being introduced in the state-based anti-discrimination legislation. For the court to be satisfied that sexual harassment has occurred, it must be satisfied that the conduct is sexual in nature, the conduct is unwelcome, and the conduct is done with either the intention of offending, humiliating, or intimidating the person, or the conduct is done in circumstances where a reasonable person would have anticipated the possibility that the person would be offended, humiliated, or intimidated. Sexual harassment can include unwelcome physical touching, sexual or suggestive comments, making comments about a person's appearance, as well as staring or leering. If after raising concerns of sexual harassment with the person responsible or with your employer, you are subjected to detriment or threatened detriment in your employment, then this may amount to what is known as victimisation. If the court is satisfied that a person has been subject to either victimisation or sexual harassment, then it may award compensation for things such as hurt and humiliation, past or future loss of income, and any out-of-pocket expenses. Your employer can also be held vicariously liable for actions of its employees in the course of their employment. This is particularly the case if sufficient steps aren't taken to prevent the sexual harassment occurring. An employer can't simply say they weren't aware the sexual harassment was occurring. That is not a sufficient basis for them to avoid vicarious liability. If you have been subject to unwelcome conduct of a sexual nature, we strongly encourage you to seek advice on your legal rights as soon as possible.